No, that's why you're here, to learn.
That made me think. We currently, well, when I got into position, we were using UPS to ship everything to the labs. So, but now the Postal Service has the tracking. So is any agencies using that? Because it would be a lot cheaper. Like one package, a little bitty marijuana or whatever, is costing like $8 through UPS. So is any other people doing that using the regular Postal Service? And is that tracking this, it just comes with it, or is that additional?
99% of the evidence that comes to the lab comes first-class mail, untracked, believe it or not. And that's how we send it back. The only thing that goes back tracked are weapons.
So you all don't track anything back?
No, all goes back first class.
Okay.
We haven't had record of anything being lost or stolen on the way back. However, coming to us, certain agency that will remain nameless lost about, 5 pounds of pot between their agency and the first postal stop. And stupidly, not stupidly, thank God, they sent it certified, and the post office processed the empty box, and we got the empty box, and that's how we were able to figure out that the stuff is missing.
Also, you don't want to send trafficking amounts of drugs through the mail either.
You wouldn't think so, but you'd be surprised what comes in the mail.
Did you say you use?
I use the post office, but when I do it, I use those, the pink and white, signature confirmations.
Yeah, certified or priority will get tracked.
And then I can just put that tracking number in there, and it'll show that it was received by the lab. I use the pink and white signature confirmation.
Yeah, priority mail don't cost anything extra. Well, it's not extra for tracking. It comes with tracking. Kind of getting back to the guns for just a second. Anybody that's a sheriff's officer in here understand that domestic violence orders guns is completely separate than what we've been talking about with crime guns and found guns. That statute didn't change when they changed Save the Gun, thank goodness. So it remains the same. If they say destroy it, you destroy it.
So, I do work in the sheriff's office, and I haven't even touched any of our old ex parte stuff for the domestic violence. So, when I finally do that, and they are not allowed to get the guns back, or, are they, so you're saying that I can't sell or trade them, they have to be destroyed?
All right, let's see. Let me find it here. I was just reading it. That's what brought it to mind. 50B-3.1, firearms and domestic violence orders. And then find it here. Well, I think they did do an update on it. Initially, it didn't include 50B domestic violence guns, but now it says upon a hearing, a judge may order the disposition of the firearms, ammunition, or permits in accordance with 14269.1, which are your crime guns. So if we follow that, then it's telling us to go back to 14269.1, which tells us that if it has a serial number, it has to be sold and all that stuff. Sorry about that.
If they file a motion and they're denied, if they file a motion and they're denied their weapons, then you follow that law.
Right.
You can sell or trade.
Yeah, when they file the
Your
motion, the judge, when they file the motion, the judge has to make the decision based on that. Upon a hearing, which is what they have when they have the motion. Then they order the disposition based on 14269.1, which means them, a third party, or to be sold.
And then if they're found convicted, if they're convicted of a domestic assault, you have to get them back under federal law.
Correct.
That's always a tough one too, just because we're not supposed to enforce federal law, but you know what I'm saying?
Well, because I just had that this past week, and that's what I asked. Well, state law, we can't enforce it, but we have to abide, we can't enforce federal law, but we have to abide
Right.
by federal law.
Yeah.
Correct. So, I had to call and tell the guy, well, I'm sorry, but, you can't get it back. You can no longer possess a firearm because of your
Right.
assault on a female, so. But I called ATF, and ATF said that they can actually appoint a third party if they wanted to
To receive the firearm.
receive the firearm, then they can get a third party involved, which then, of course, they've got to go through all the checks and everything else, but.
Yeah, and that's one thing I had seen after they done the save the gun law. A lot of people were applying for that third party thing, which I don't know. I don't know if I agree with that or not. Yeah, he sold them to me. Well, where's the receipt? Hang on, I'll go get it for you. And then he shows up with a handwritten receipt that says, "Yeah, I sold him a gun." Don't have a date, nothing to determine when it was signed. So. Yeah, I don't agree with those. Go ahead.
I have a question. Does anybody ever get orders in here, like we was talking about 50B? We get orders from the judge that they've activated the 50B for 1 year, but we are to return the guns to them.
I've never heard that. I think,
We just got 2 in the past week that the judge himself wrote on the order that the plaintiffs have agreed to have the 50B in effect, but the defendant can have his weapons back. But he can possess his weapons.
right. But they done the motion and had a hearing and everything?
No, this is going for the 50B. They've went to court for the 50B. They granted the 50B, but the judge put in there that the defendant can have his weapons back. But the 50B stays in place for a year.
Is that on the regular order?
Yes.
Like the one where you return them to them or destroy them or
This
whatever?
is actually, no,
A
this is,
separate, like
is
a
the-
handwritten order?
yeah.
I don't think they're supposed to do that.
I didn't think so either.
But that's what I've been talking about too, is if the judge orders it, I mean, really,
What can we do? I know.
other than approaching, and we have had this happen where some of our judges, district court judges especially, are handwriting on that AOC form that it be destroyed. And we've had to have a meeting with the chief district court judge to say, look, I don't know if they're intentionally doing this or are they just not aware, but this is what's happening. And he was going to sit down and talk to all the judges that you're
No,
not
they're
supposed
writing
to
it
do
on
that.
the 50B. You get the actual 50B, where they say stay away 1,000 feet and all
Mm-hmm.
this. On the bottom of it, it says they're in agreement. The plaintiff and defendant is in agreement that the defendant can have his weapons back, and the judge is signing and saying that he can have his weapons back. But the 50B is in place for 1 year.
The only thing I would say to help you out without having to get something started with a judge is you tell the defendant that you're not going to accept that unless it's on that AOC form. I can't remember the name of it off the top of my head. Then you have an actual court order that says, I'm telling you to do this. Then you'll be covered. But I always ran into trouble with the motion for return is, people go to court and they have their hearing and they do away with the protection order and then they come over and say, well, I want my gun back. Well, you still have to go through a hearing to determine whether you get your gun back or not. Or even so much the attorneys will tell them, well, just, you're done, just go over and get your guns, or the clerk will tell them, just go over and get your guns, and then we send them back across the street and do the whole hearing. Is that all? Go ahead. Right here.
So what about the safekeeping firearms? I keep asking this question of what my chief wants me to do, and he gets all kinds of crazy answers from people in his community that he reaches out to. And now we've got a city attorney who, he's proposed some process. If for some reason I don't think that the law allows me to give a gun back, that there's some disqualifier.
Mm-hmm.
Our city attorney has advised us to go to some planning board if they want to refute that. I don't know. I don't want to keep anybody's gun, ever.
Right.
No, I don't want it. I want it to
Right.
go away.
But you don't want somebody that's not
But I
supposed
don't want the
to have.
liability of,
Right.
of giving that back. And how do they prove to me that they're okay to take it? I've been advised to, have them have a judge give a court order that they can have it back. And some people advise getting a permit to purchase.
Mhm.
Do you run a criminal history?
Yes.
So, I mean, you should be able to run the criminal, I run a criminal history, I run AOC, and I run a driver's license. Because driver's license hits on the, Department of Corrections, because if they're on probation, they can't possess either. So I run all three of those to make sure that they are that they're able to possess a firearm. So as long as they fit within that, there should be no reason to hold it.
I've
And
looked at
coming
the-
from a sheriff's office,
Without
I'm,
a commitment,
And I think that's the hard thing to find out.
We track in our system, Very we hard to enter,
Oh,
in-
find out.
we track, whether or not they've had an involuntary commitment, because they get entered into our system. So I can pull up, John Doe and look under his involvements, and I can see everything that we've touched on him, and whether or not he's had an involuntary commitment. If he's had the involuntary commitment, then we're gonna have to go through the process of finding out whether he was adjudicated or, what all that process is. But if he has never had any involuntary commitments or anything through us, and his criminal history's come back okay, he's got no outstanding felonies sitting in court pending, and he's not on probation, then we go ahead and release it.
And I think we don't have as much access to the involuntary commitment on a
Right,
police
that would be
side.
the sheriff's office, right.
So, that's something that we don't know about.
So what
I guess you would need, I guess if you were to get him to get a permit, then
Yeah, because we don't have access to that either. We're a police department. So what we got is I will not release the gun until you have a valid concealed carry or gun permit, and valid that it's the current sheriff, and it's not expired and all that, and then you have to show your ID, of course. That's the only way I would give it back. Say if it was evidence or safekeeping, like if they were arrested for DWI and the gun was in the car, and they can't take that to jail, then I'll give it back once they present that. If it's for safekeeping, like we had one, I had over 20 guns from a attempted suicide or threatening suicide. So they brought all the guns out of his home to us for safekeeping. So in that instance, because he has mental, like his wife said, like he, when they went to the call, like he's had a history of making threats and just sometimes acting kind of crazy. So in that instance, because he did have a valid permit for all those guns, however, because it was a mental safekeeping, I got a court order. So that way, it's not on me if he takes those guns back that same day and kills his whole family. It's not on me. I tell him, because of the stats, and I was looking for my paper. I went to a meeting with you all, and we had that. It was a list of disqualifiers, and it was one for drugs. That's like if they got a history of drug abuse, the felony thing, and mental instability. So, I just got a court order. And I just got another one recently from a person who was impersonating a police officer, and it was an old case, but we still had his guns. I talked to his mother and sister, and they were like, please don't give him his guns back. Because I called them, I was like, we have your son's property, because they end up, he didn't get jail time. He had to go to, get mental help. But they was like, please don't give it back. And I was like, well, I'm going to have to get a court order not to return it to him because of his mental status. And that's what happened. I just got it back this week, actually, and they signed it and said, due to his mental status, we would not be giving him his guns back. So that's just what we do because we don't have access to that. But if you make them display a permit, then they get that check from the sheriff's department. So you kind of cover your bases.
Yeah, and safekeeping can really be slippery. But like they're pretty much saying, making them get a permit is really, I've had ATF agents say that we're supposed to do that anyhow because we're transferring a firearm, and anybody that transfers a firearm is supposed to have a permit. Well, that's one of the easiest background checks. It's a official background check that you can rely on because it ain't just them going out getting something. But safekeeping can be particularly bad. And we were still using voluntary destruction as well. So if we seized a firearm, if somebody attempted to commit suicide or whatever, and they cleared the case as such, the person can come in and actually sign a paper that says, I'm voluntarily giving up my rights to this firearm and I wish for it to be destroyed because it's no longer needed for an investigation. But you have to make sure you're not within domestic violence, the three categories, found property or crime gun. Mm-hmm.
Domestic violence, that just throws a whole other curve in it, because they may have assault on a female, but you also then have to check into, well, what was the relationship, what was the